Hello, everyone. Welcome to another Agenda IDS. I am Patricia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share their expertise with us. And those who miss the live event will be able to access the record content available later on the Dannemann Siemsen Institute website. And today, we will debate about trade dress infringements, talking about a global view of the subject and how it is dealt with in Brazil. And to discuss this topic today, we invited three experts. Please let me introduce our guests. To talk about the issue in a global perspective, we invited Ms. Bence Bozóki. Welcome, Bence. Bence is a Senior IP Counsel at Mars, supporting the company's confectionery business globally. Bence specializes in enforcement strategy, trademark litigation, and built a strong global portfolio. He is known for his success in combat lookalike products. And to discuss the matter as regulated in Brazil, we have with us today Mauro Ivan C. Ribeiro dos Santos. Welcome, Mauro. Mauro Ivan is a lawyer and a partner at Dannemann Siemsen. He has a postgraduate degree in copyright and related right from King's College London University and a master's degree in intellectual property from Boston University. He works in administrative and judicial area for more than 30 years, representing the local and foreign clients' intellectual property matters. And to moderate the event, we invited Rafaela Borges Walter Carneiro. Welcome, Rafaela. Rafaela is a partner at Dannemann Siemsen. It's a lawyer, and she holds a LLM intellectual property from Philipps University Marburg in Germany. She works at all levels of the trademark protection process, and her expertise included the strategic management of national and international portfolio. I would like to thank you very much, our guests, for being here with us today. Now, I will give the floor to Rafaela. Thank you very much.
Hi, everyone. Very nice to have you guys here. Hi, Bence. Thanks for accepting our invitation. Hi, Mauro. So before we start, we will actually divide our section in two parts. We will start with Bence. Then we will go to Mauro with this our local and Brazilian perspective, and questions will be answered after they have finished. We tried to choose or to find some definitions about trade dress, and the idea of having this topic in the discussion is that we have been watching and seeing many cases, not only at the administrative spheres, but also in the judicial spheres in Brazil and in international level. And trade dress is always something that is interesting to discuss about because it has a very subjective quality in it. So one of the definitions that I liked most was the one that I found with INTA, and it says something like trade dress, the overall commercial image. It's what we call the look and feel of a product or a service that indicates or identifies the source of this good of services and from any other one. Depending on the jurisdiction, it may, for example, include the design or configuration of a product, the packaging of goods, or the decor or environment in which the services are provided. Classic example of that is the Apple Store. And there were some discussions of the protection of the store itself, and also some other kind of establishments. So the trade dress can consist of such elements such as size, shape, color, and depending again on their jurisdictions, trademark, design right, copyright, or even patent law may afford protection to trade dress. So now turning to Bence, I will start asking him some questions. And the first one is, Bence, how important is a product's trade dress when it comes to consumers choosing that product over others in the market? What do you think about it?
Thank you for the question, Rafaela. And also, I'd like to take the opportunity to thank Dannemann Siemsen for the invitation to this webinar. It's a pleasure to be here, and also pleasure to speak with everyone on this webinar. I myself am based in London. I've been with the Mars company for about 9 years now, and mostly working in the chocolate and confectionery space. So I have global responsibility for trademark work, including brand enforcement. And as you can imagine, we encounter quite a few lookalike products or trade dress infringements globally. But my view is predominantly based on this sector and category of food and chocolate and confectionery that we work with. So bear in mind, when I'm answering these questions, I have this sector in mind first and foremost. So the importance of trade dress for consumers, I think it's absolutely vital. It's essentially, there's scientific data that shows that it is actually the basis for trust and also for the purchasing decision of the consumer. And when I say science, what I mean actually is behavioral science. There's many studies published in this area, but I think most recently in the UK, there was a study commissioned by Stops, the IP firm, that actually showed how important psychology is and how consumers behave specifically in a supermarket environment. And according to that data, it is actually, the trade dress is much more important than, for example, the name of the product, the brand name. The data actually gives 3 key findings. One is if the consumer is in the store, they rely on what we call system 1 thinking. So it means that decisions are made outside conscious awareness, effectively. And you will get different results if you assess the consumer behavior directly compared to when you ask the consumer, why did you purchase that product? So it's that nuance that they will give a different answer compared to what actually drives them to purchase the product. So that was the first key finding. The second key finding is basically how consumers perceive color, and basically color and shape are those elements of the product that should be really given more weight, even in IP, because those are the decisive characteristics of the product that actually drive mental availability and purchase. So those mental shortcuts that we talk about in trademark law and IP law, they're triggered by much more by colors and color combinations than they are triggered by brand names. And then lastly, the third key finding of this psychology of lookalikes is that the consumer perception of an actual lookalike product improves with similarity. So basically, a product is basically thought of as having better characteristics, better quality, if it is reminiscent of a famous trade dress, for example. So it has this positive connotation, which is what these lookalike producers or trade dress infringers try to exploit, essentially. So, I mean, the conclusion of all of that is pretty much that the consumer will remember the well-known trade dress, and it will trigger those mental shortcuts and positive associations that actually leads to buying the product. So it's super important and also a good reminder for brand owners around the world to actually create inherently distinctive packaging and branding, and then enforce against imitations worldwide. Because if you don't do that, then your branding effectively dilutes over time.
My next question would be, do you think that competitors, that they have parameters and standards when it comes to copying the trade dress of a market leading product? How they usually behave?
Thank you, Rafaela. So I think it's a great question. It always depends on the sector and industry of where these players would compete against one another. But based on also the answers to the previous question and based on science, colors are very often copied alongside logos or script styles, whereas brand names are copied less so. And however, the brand name often starts with the same letter to give that additional association. But I think colors and color combinations, distinctive features, are copied more often, because also I think they can get away with it if they don't copy the brand name. And then I think there are several claims that the trade dress infringers would make, or they would sort of defend their behavior in certain ways. And one of the claims is that they are effectively benchmarking against the entire competitive set, the entire category, and not just the market leader. Whether it's true or not, you would have to sort of decide yourself based on the facts of the case, but that's what they often say. But what we see and what happens often is that even if they say that, they would actually single out the market leader and copy their trade dress. So what they also say often is that they are using what they call category cues, or colors that define the category rather than the brand. And basically, they also say that due to the fact that these are category cues, they are not ownable and they're not distinctive in the category, so they can use it. Again, often this is not true, but often it is claimed. And then they also claim, I think, usually two more things. One is that there's no confusion, so that the consumer is not confused effectively. So the consumer is not stupid. They can see that this is a different brand name, different product altogether. So that's what they would also say. And not only that, that's not confusing, but also that is actually helping the consumer to find a cheaper alternative, or of a product of the same quality. But as you can see and hear, I'm a little bit kind of skeptical of these claims. And effectively, I think personally that the goal is to achieve what we call change of economic behavior on the side of the consumer through the image transfer. So these cases are often image transfer cases, where image of a famous brand is transferred to the other product, and the economic behaviors change so that the consumer does not buy the branded product, but they buy the lookalike product. So that's the sort of goal of the competitive behavior often. And what would also happen is that they would test the waters. So they would go out with a trade dress, launch a product a little bit similar, and if they are not challenged, then over time they tend to kind of creep closer to the original one if they remain unchallenged. And also, I think obviously in some countries, brand owners have it easier than in others. So I think they know that, and they monitor the IP framework and case law so that they can effectively go as far as they are able to without infringing. And yeah, I think all in all, what I think is they are essentially, as I said, achieving a change of economic behavior through manipulation of consumers, of their system one thinking, the more intuitive thinking, into buying products that they think have the same quality, whereas often this is not the case.
Perfect. What do you think that IP owners and their attorneys, lawyers should consider to protect and enforce trade dress against other imitations or infringements in the market?
Yeah, no, I think this is interesting and also based on the jurisdiction, and I would be really curious to hear Mauro later speak about Brazil as to what is possible in Brazil and what is, to the contrary, what is difficult in Brazil. Globally, I think what is proving to be more and more common and effective is to actually try and somehow protect the overall impression of the packaging or branding, not necessarily simply individual elements of the packaging separately, but protect it all together, maybe as a front of packaging trademark registration potentially, and then build recognition of this packaging, of the trade dress over time through marketing campaigns that hero these assets and the front of back. And then I think for enforcement, you mentioned, Rafaela, in the introduction, that you can rely on several different, IP regimes, trademark infringement. Within trademark infringement, you have likelihood of confusion, and also unfair advantage as well. Others as well, but those are most common, I think. And then you've got copyright infringement, obviously, design, unfair competition, very commonly. Sometimes people would also mention consumer protection laws or misleading advertising, things like that, but it's less common. And depending on where you are in the world, you need to consider these, but most commonly unfair competition, I think, where available, and where not, then as aspects of trademark infringement where you have the right protection that I was talking about, and then the recognition in that packaging. And then in terms of, obviously, you have to think about what can I prove? Can I prove confusion? Can I prove dilution? Is it harming the consumer more? Is it harming the brand owner more? And then if yes, then how can I prove that, right? I think in a more difficult jurisdiction, I think likelihood of confusion will be quite hard to prove. For example, in where I'm from in Europe, you have unfair advantage, which if you can't rely on unfair competition in some jurisdictions, you go with the unfair advantage claim, which doesn't require you to prove confusion, but it requires you to prove that there's a link in the consumer's mind to the trademark with reputation, and there's also a transfer of image happening, a change of economic behavior. We talked about this before, and then there's an advantage as a result, an advantage that the lookalike producer would gain by this. And really, again, I would be curious to hear later if it is possible to rely on this in Brazil without having to prove confusion. I think what is important to note is overall, imitations not only exploit the basic function of a trademark, which is the indication of origin, but also they tend to exploit other functions of the trademark, such as advertising function, quality function. And I think that kind of argumentation helps convince judges that actually you have to look at more than simply looking at confusion in a case like this.
Now, in your experience, what should be taken into account to increase the chances of success in a court action or in a dispute involving trade dress infringement? And what do the courts take into account when deciding these cases?
I think you see a lot of different ways courts would look at lookalikes, and depending on where you are in the world, it could be brand owner friendly, for example, like Germany, or much less brand owner friendly, like the UK. And what I think should be taken into account is, as I said at the beginning, for example, behavioral science should be taken into account. I think, yes, judges are experts of the IP law and trademark disputes, but are they experts of behavior science? Most of them are not. So how consumers act in store and what influences their decision is, you can't really assume one way or the other. It's a lot of that is scientific. And then one other thing that needs to be just taken into account much more than I think it is in most jurisdictions is the actual similarities in the overall impression and the colors and color combinations, whereas I think less emphasis needs to be on words, on pack and brand names. And then lastly, to my point earlier, which is essentially that not only confusion or likelihood of confusion infringes, that there is much more to an infringement than simply likelihood of confusion. I think dilution also is an infringement, or should be, and that's going back to what I said about the functions of the trademarks and how those functions are infringed separately and cause consumer effectively to behave differently. Yeah, so that would be my answer to that.
Great, thank you, Bence. Now moving to Mauro, we are going to have some specifics on the Brazilian perspective and his experience in dealing with such cases. Mauro, you can start your presentation.
Thank you, Rafaela. First of all, thank you for the Instituto Dannemann Siemsen for having me today. Great pleasure to be here with you, Bence, Patricia, and special thanks for the audience as well. In my presentation, I will use some slides, so I will share my screen with you. Just a second, please. Okay. So,
okay.
Yeah, okay.
Let me jump in and make the first question. Mauro, what are the specifics of trade dress protection in Brazil, and so generally speaking?
Well, yeah, first of all, I'll give you a general overview about the subject. Starting again, yeah, I know that you mentioned this before, but starting again with a definition about trade dress. Trade dress is essentially the overall look and feel of a product, packaging, or service that identifies its source. So is a source identifier. It can encompass a wide range of elements, including, and that's important because trade dress is complex exactly because of this wide range of elements that can be encompassed. So, in related to the product itself, trade dress can encompass the shape, the overall configuration of the product, design, decorative elements, patterns, or motifs of the product, color, unique color, a combination of colors, texture, the feel of the product surface, in materials, the materials used in the product's construction. So, the packaging instead of the product can also contain a lot of trade dress elements. Shape, again, the configuration of the packaging, design, graphics, images, or text of the packaging, color, typography, the fonts used in the packaging, and again, materials. So you have also service-related elements. So not only products, but service can be subject of trade dress protection. Services, you have mainly the decor, the overall ambience and design of a store or restaurant, maybe the menu, the appearance and layout of a menu, uniforms, and advertising materials. And finally, we can also consider as part of a trade dress, sounds, unique sounds associated with a product or service, and also scent, a distinctive smell, fragrance linked to a product or service. So, Brazil, like many other countries, lacks specific protection for trade dress, legal protection for trade dress. Trade dress infringement lawsuits can involve copying of products, labels, packaging, and even the look and feel of stores, among many other things, as we saw in the beginning of this presentation. Parts of the elements that composes a trade dress can often be registered. That's important to say. As Bence mentioned this in his presentation. You can have protections as a trademark, industrial designs, copyright, but registration is not necessary to sue someone in Brazil based on trade dress infringement. But the fact that we don't have specific legislation here makes us to have to rely on broader legal concepts. And among them, I point out to two legal provisions that are important. First is Article 5, Item 29 of our Constitution, that says that the law shall ensure the inventors of industrial inventions and temporary privilege for their use, in addition to protection of industrial creations, ownership of trademarks, company names, and other distinctive signs. This is the important part here. The Constitution affords or has protection for any other distinctive signs. This is a broad understanding, and you can understand that trade dress is protected under this definition, part of this definition. Article 1953 of the Brazilian Industrial Property Law is also very frequently mentioned in a trade dress infringement action, and this section of our law says that a crime of unfair competition is committed by he who uses fraudulent means to divert for his own or a third party's benefit another's clientele. So these are the basic two elements that you have, and I add a third one here, that is section 10b(2) of the Paris Convention for the Protection of Industrial Property. This international convention applies to Brazil as well. And the convention says that any act of competition contrary to honest practice in the industrial or commercial matters constitutes an act of unfair competition. So this is basic, the legal framework that we have here. And before I go to some specific cases, I would like to mention that we, in preparation for this presentation, we ran a case law search, but not focus on the merits of the decisions, but instead on identifying the main sectors of the economy in Brazil, the main sectors here that are involved in trade dress litigation. And we ran the search before the Superior Court of Justice database, and also before the some Court of Appeals database. And we try to identify companies from litigations involving these companies over the last 10 years. And the results, as you can see, show that in most of the trade dress litigation cases, we have the cosmetic and personal care industry involved, or the food industry involved, or the pharmaceutical industry involved, or still the beverage industry involved. These are the main players in Brazil in these actions. We also identified not the same level as this four, but also other important players, and I mentioned here the gas station segment, toys, apparel, household appliances, and cleaning products.
Mauro, yes. Can
okay.
you comment specifically on trademark litigation in Brazil?
Yes, I was about to start making some comments about some specific cases. I will start with this case involving backpacks, and this was a decision by the Superior Court of Justice in Brazil. The Superior Court of Justice is our court of last recourse for infraconstitutional matters. And in this case, plaintiff was Oakley. Oakley filed this lawsuit against Wise Comércio to seize backpacks imported by Wise, claiming they copied the trade dress of its products. Oakley's lawsuit was initially dismissed for lack of a registered trademark on industrial design, but Oakley filed a successful appeal to the São Paulo Courts of Appeal. The Court of Appeals recognized that the protection of a product's trade dress doesn't depend on formal registration, and the court found that Wise Comércio had unlawfully copied Oakley's trade dress and awarded damages to Oakley. Wise, in turn, Wise Comércio, the defendant, in turn, filed an appeal to the Superior Court of Justice, arguing that because the products were seized by the Brazilian customs and never reached Brazilian consumers, Oakley couldn't claim any damages or moral injury. In the decision, the Superior Court of Justice first reaffirmed its position that trade dress is protected even without a prior registration obtained before the Brazilian Patent and Trademark Office. The reported justice in this case highlighted that trade dress is protected regardless of any registration by Section 5, Item 29 of the Constitution, the one that I've just mentioned, and also based on the unfair competition provisions of the Brazilian IP law that I also mentioned. In addition, this decision reaffirms the principle that in case of IP infringement or unfair competition, damages are presumed. This means that proving the illegal act is enough to establish material damages without the need to demonstrating actual losses. And lastly, and important, the Superior Court of Justice in this case set an important precedent by expressly recognizing that moral damages can be presumed and can be awarded in case of trade dress infringement or unfair competition in Brazil. That was the first case. The second case that I would like to mention is this one. Is another special appeal, an appeal to the Superior Court of Justice. This one was decided by the third panel of the Superior Court of Justice. And this case, Ipera S.A., the owner of the Engov blister and trademark, filed a lawsuit against Laboratório Catarinense LTDA, claiming that the packaging for post-drink copied the look and feel of Engov, leading to confusion and undue association. Laboratório Catarinense, in turn, claimed that although both products used the blue and yellow packaging, they displayed different trademarks, and therefore there was no unfair competition or confusion. Laboratório Catarinense also argued that since colors in themselves cannot be subject of exclusive rights under our industrial property law, the company could not be held liable simply for using similar colors. The trial judge decided that Laboratório Catarinense had engaged in unfair competition, concluding that there was a risk of consumers' confusion or association. Accordingly, the judge ordered Laboratório Catarinense to cease any use of the post-drink product and pay material damages. Laboratório Catarinense appealed this decision, arguing that the marks were different enough and that the colors can't be protected. The São Paulo Court of Appeals upheld the lower court's decision, but did so by a majority of votes. And because of that, Laboratório Catarinense then appealed to the Superior Court of Justice, and then the appeal was accepted for examination and judgment. So the third panel of the Superior Court of Justice examined the case in detail and found that Laboratório Catarinense intentionally copied the Ngov package, and in doing so, the panel said that, concluded that both products competed in the same market. The Ngov product was on the market first, and the trade dress of the Ngov was widely recognized by the consumers. The court, in this case, pointed that the difference between the marks Pós-Drink and Ngov, both registered before the Brazilian Patent and Trademark Office, was not enough to prevent confusion and association between the trade dresses. The court concluded that the plaintiff's Ribeiro's product had a solid reputation in its segment, and therefore its consumers purchased the product mainly based on the overall trade dress appearance, and not specifically because of the mark Ngov. The mark Ngov itself, which it is a well-known trademark in Brazil, but even so, according to the court, the public was much more used to buy the product based on the overall impression of the trade dress instead of the mark. So that was a summary on this important decision. But interestingly, the same panel of the Superior Court of Justice, in similar case involved Grandene versus RS Calçados, involving these sandals here, adopt a different position, upholding the lower court's decision, in which the court of origin found that there was no risk of consumer confusions in the sandals regarding the trade dress of each product due to the prominent presence of the respective manufacturer's trademarks on the sandals they produced, and because the appellant's trademark is a strong distinctive sign in the consumer's market. So here, Ipanema it was considered a strong and well-known mark in the sector. But in this decision, contrary to the other, the court understood that the mark had played an important role in this litigation, and considered the products likely to coexist. So this is to show how subjective in nature is a trade dress litigation, and it's difficult. We can find decisions in different directions. Finally, a third case that I believe is interesting to talk about is this special appeal involving the owner of Neutrox and the owner of Tratex, two trademarks in the shampoo field of business in Brazil. In this lawsuit, JF Participações, owner of the Neutrox product, claimed that Dragão Química Ltda, owner of the Tratex hair product, copied the Neutrox trade dress, formed by its cylindrical shape, yellow color, and red cap. The trial court ruled in favor of JF, but Dragão appealed and won in part. The Court of Appeals applied in this case, and that's interesting, the 306 degrees test, which I will talk a little bit more in a few seconds, and decided that Dragão was not engaged in any act of unfair competition. JF appealed to the decision, arguing that the court made a mistake by not following the Brazilian law on trademarks and unfair competition. The special appeal filed by the JF was unanimously dismissed by the third panel of the Superior Court of Justice. But the judgment emphasized the importance of the 306 degrees test, and this is a test that was created by two lawyers here in our office, Dannemann, Felipe Cabral and Marcelo Mazzola. They proposed this test in an article a few years ago, and the test has been adopted in several cases involving trademarks. And now the interesting thing is that the courts has started applying the test also in connection with trade dress cases. This test, so this is the 306 degrees test. Helps to determine the similarity between trademarks and trade dress. And the test consists of factors such as how distinctive the trademarks are, how similar the trademarks look and sound, the reputation of the alleged infringer, how long the trademarks have coexisted in the market, the type of products involved, the target market, and whether the trademark has been diluted. Well, based on this test, the Rio de Janeiro Court of Appeals decided that there was no unfair competition by the owner of Tratex, a decision, as we saw, subsequently upheld by the Superior Court of Justice. In light of the above, the reporting just pointed that a reevaluation of the matter was inadmissible, and as I said, dismissed the special appeal from JF. The court also ruled that the plaintiff's claim was barred by the principle of laches, as they waited over 40 years to take legal action. This is one of the killing arguments raised by Tratex, exactly that the products had been coexisting in the market for over 4 years. Just a few years ago, Neutrox started a litigation and trying to bar Tratex, the company, from using Tratex because of trade dress infringement. But of course, after 4 years of peaceful coexistence in the marketing, the court ruled that this wouldn't be possible. And the court also highlighted that the time, in addition to the time of coexistence in the market, dilution also applied to this case because several other players or competitors in the market, in this specific market, were using more or less similar trade dresses, involving cylindrical packaging and same colors. So the overall appearance was diluted. So the decision here was against the plaintiff.
Mauro, do you think there are any other relevant factors that you think it would be interesting to comment on?
Rafaela,
regarding these cases?
Rafaela, just before, can I tell the audience that they are free to ask questions in our chat?
Oh, sure, yeah.
Only to let them know. I'm sorry to interrupt, but only to let them know. Please feel free to make asking to the lectors in the chat. Thank you.
Okay, Rafaela. Yes, I think that there is one additional issue that deserves to be mentioned here today. And this issue has to do with expert analysis in cases involving trade dress. Well, judges still decide a considerable number relying on their own perception to determine if there is a risk of confusion. However, the Superior Court of Justice has ruled since 2017 that experts' testimony is necessary to prove trade dress violations. And here I will mention two decisions in this regard from the Court of Appeals. First, one from the third panel. The third panel, in the decision, a special appeal published in 2017, ruled that the confusion that characterizes unfair competition is a factual issue subject to technical examination in order to verify the market in which the good or service is inserted. And concluded that the denial of technical evidence replaced by experience as a substitute for evidence is a conduct that restricts or may restrict the party's right to defense. So this was the third panel, a decision from 2017 from the third panel, and then we have a similar one, more detailed, from the fourth panel of the Superior Court of Justice in 2018. In this one, the fourth panel of the Superior Court of Justice decided that the overall image is complex, talking about the case itself, and comprises of various elements. In the absence of specific legal provision and given its non-registrable nature, determining whether imitation has occurred and constitutes unfair competition must be assessed on a case-by-case basis. Expert input is crucial to evaluate market factors, consumer behavior, advertising and marketing strategies, the level of attention of the average consumer of the product, the product's launch date, and other distinctive features of its presentation. So again, emphasize the necessity of having experts input in these cases. And these two decisions were followed since then by several others from the Superior Court of Justice. Therefore, we may conclude that the denial of a request for experts' testimony in trade dress infringement actions can be considered a denial of defense, which has led to the annulment of judgments and decisions. And therefore, and thus, it is recommended that experts' testimony always be requested in this type of action.
Yes, any final thoughts, recommendations, suggestions, anything that you would like to share with us in your experience and cases that you have been involved with?
Yeah, just a few conclusions based on the case law research that we performed and on the presentation of Bence as well. Trade dress protections in Brazil has some specific issues and difficulties. First, it's complex. We have a difficulty in defining trade dress because of the broad elements involved, and the trade dress has a complex nature and makes it challenging to define and protect. Second, case-by-case analysis. Each trade dress case requires a specific analysis based on its particular circumstances, making it difficult to establish general rules. Third, we have this issue, balancing competition interests. Courts must balance the rights of trademark owners and trade dress owners with the need to promote competition and innovation. And finally, now, as I mentioned in the end of my presentation, role of experts' testimony. Experts' analysis is crucial in asserting the complexity of trade dress issues and providing a technical foundation for judicial decisions. So I think that these are some important elements to have in mind. And with this, I finish my presentation. Thanking again for your patience and for the audience to have followed us today.
No, thank you guys for sharing with us your experiences. And yes, it is not easy to talk about trade dress. I'm pretty sure that everybody here has different approaches and results, and sometimes we think that it is a case that we will win, and it isn't something that happens. So we have some questions in the chat. The first one for Bence. It says, trade dress copies are very common in Switzerland. One of the biggest supermarkets here has traditionally copied trade dresses of other brands throughout the years. Nowadays, besides Migros, also Lidl and Aldi, these are very famous supermarkets, are big on copies. How have you been dealing with these cases in Switzerland in the past? As a consumer, I am usually also looking for the cheaper option with similar trade dress. Bence, could you share the UK study you mentioned with us? So first question is, how have you been dealing with cases in Switzerland in the past? Yes.
Thank you for the questions. I saw the question. I've started to think about Switzerland, and I don't remember a specific case in Switzerland actually in the past few years that we have worked on. But what I do know is also based on the question that it shouldn't be very different from the rest of Europe in the sense that unfortunately some parts of Europe are kind of notorious or known for lookalikes, and quite often these would be as Anna also mentions in the question, retailer lookalikes. And when we deal with retailer lookalikes, it's highly sensitive, and careful consideration must be given to the fact that we have a business relationship with the retailer as well. So whilst we address the issues that we have, they are addressed with consideration and using the good relationships we have with these companies. So I think the sensitivity there is rightly pointed out with those retailers that are mentioned. Yes, the reaction as well to looking for the cheaper option. I think it's legitimate in a cost of living crisis or in a difficult economical environment that we have in I think many countries of the world. It's legitimate, but also you have to draw a line as to how much you are relying on others who have built their branding over the years, and how much you're relying on them to win over consumers. So there's an element in that I think we all feel a little bit who work in these cases that is kind of not right and crosses a line. So there's no problem with cheaper alternatives if they don't sort of hijack some of the intellectual property. And yes, I can share the study that I mentioned, and if possible through Rafaela or Patricia, I can email, and then it can be requested from the Dannemann team.
Great. Then now we have a question for Mauro, and that's it. I realize that due to the absence of specific legislation, we have to use broader legal principles. Do you think we could apply the Consumers Code for trade dress disputes in Brazil? And if yes, what would those principles be?
Well, the Code of Consumers Protection has a specific provision that deals with the protection of IP. I think that is section 4, item 6 or something like that. And because of that, we have a specific provision here that applies. And as a general principle, yes, as well, because we as a whole, if you have any act that is likely to prejudice the consumer, we can apply the basic principles of the consumer protection law as a whole. But we have this specific provision. I believe that's Article 4, item 6.
Yeah.
So it is. So yeah. So that's something that can be used together with the notion of unfair competition and the sections that I mentioned about the federal constitution, the IP law. We have other provisions that you can apply as well. For instance, unjust enrichment that is established in section 884 of the Civil Code is another one that you can apply. And actually, if you have protection for parts of your trade dress, as for instance, as a 3D trademark or industrial design, or even copyright in elements, we can also apply the copyright law and the industrial property law, specifically regarding trademarks and industrial designs.
Yes. As I said in the beginning, the more elements we have to build the case the better, and depending on the jurisdiction that we are fighting as well. So yeah, but we always have, I remember now in some recent cases, we always cite this specific rule of the Consumer Protection Code. Another, maybe it's the last question, another question to Bence. What type of evidence, in your experience, is more effective to convince courts to grant preliminary injunctions and positive judgments against infringers?
Thank you for the question to Felipe. I think it depends on a lot on the jurisdiction, because some type of evidence is commonplace in some jurisdiction, whereas in others it's almost inadmissible or completely ineffective. So it will definitely depend on that. I think where we had successes specifically in preliminary injunction proceedings in Germany, we've done market surveys which kind of show the competitive set and how the trade dresses look like, and if a unique trade dress is being copied, it is more likely to be considered an infringement. And also, I think this unique trade dress has to have at least a degree of awareness or reputation in the eyes of the consumer. So proving that is very important as well. And then I think hopefully in the future at some point, more and more courts will consider also behavioral science as far as it's kind of impartial and shows proves the relevant points that need to be proven according to the law.
Yeah, there's a last question, a very last one, and it is, are there any specific criteria that should be taken into consideration for pharmaceutical trade dress? Mauro, can you, so if you remember any case, or Bence?
Well, there are some ANVISA's guidelines regarding the package of pharmaceuticals. So sometimes we have some restrictions about how to expose your trademark or the trade as a whole because of that. So yeah, you should pay attention on this when you are defending your case. If you are not restricted by some functionality because of this restriction, so you have to pay attention to that. But generally, I would say that not only for the pharmaceuticals in general, whenever you file a lawsuit based on trade dress, it's important to support your claim with very substantial evidence, and in general, we have been doing so through an expert's semiotic report. It's not the expert's analysis of the expert appointed by the judge, but initial analysis by someone that you hire to prepare a detailed comparison between the products. And this is important in case you want to obtain a preliminary injunction order in general. Of course, after that, the judge, based on the Superior Court of Justice recent decisions, will probably designate, appoint an expert to give an impartial opinion. But your initial brief together with this kind of report is important as well.
So guys, I think we have to end our session today. So thank you, Bence, again for joining us. It was a pleasure. I hope to see you soon. Thanks, Mauro, for sharing your experience and some cases, and Patricia and IDS. And I hope to see you guys very soon. So thank you. And if you have questions, please, you can send to us and we can answer them and send our answers back to you. So thank you so much.
Thank you,
Bye-bye.
Rafaela, Mauro, and Bence. And thank you,
Thank you
the
very much.
audience. And please follow the IDS in our social media and website. We have have new content to come in. And thank you. Bye-bye.